Hello and welcome to Bar10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. To that end, we upload content every day at 8 a.m. Eastern Standard Time. Let's get right into this grouping with question number 1. Question number 1. Dora, who was 8 years old, went to the grocery store with her mother. Dora pushed the grocery cart while her mother puts items into it. Dora's mother remained near Dora at all times. Peterson, another customer in the store, noticed Dora pushing the cart in a manner that caused Peterson no concern. A short time later, the cart Dora was pushing struck Peterson in the knee, inflicting serious injury. If Peterson brings an action based on negligence against the grocery store, the store's best defense will be that A store owes no duty to its customers to control the use of its shopping carts. B, a store owes no duty to its customers to control the conduct of other customers. C, any negligence of the store was not the proximate cause of Peterson's injury. Or D, a supervised child pushing a cart does not pose an unreasonable risk to other customers. Take 10 seconds. If you chose option D, you'd be right, and you're off to a good start. A, supervised child pushing a cart does not pose an unreasonable risk to other customers. If a duty is owed to those on the premises, the owner can satisfy the duty of reasonable care by either making the condition safe or issuing a warning of a dangerous condition. An invitee is either a person invited onto the land to conduct business with the owner or a person invited as a member of the public for purposes for which the land is held open to the public. A landowner or occupier owes a duty to invitees to conduct activities on the premises with reasonable care. Here, Dora was near her mother at all times in the store. Peterson noticed Dora pushing the cart in a manner that caused Peterson no concern. Dora did not seem to be creating an unreasonable risk of harm by pushing the cart. So the grocery store was not in breach of its duty to ensure activities on the premises are being conducted with reasonable care. Accordingly, store's best defense to Peterson's negligence action will be that a supervised child pushing a cart does not pose an unreasonable risk to other customers. Question number 2. Parker sues Dix for a breach of a promise made in a letter allegedly written by Dix to Parker. Dix denies writing the letter. Which of the following would not be a sufficient basis for admitting the letter into evidence? A, testimony by Parker that she is familiar with Dix's signature and recognizes it on the letter. B, comparison by the trier of fact of the letter with an admitted signature of Dix. C, opinion testimony of a non-expert witness based on familiarity acquired in order to authenticate the signature. Or D, evidence that the letter was written in response to one written by Parker to Dix. Take 10 seconds. C is your right answer. If you chose C, once again, you're off to a great start. Opinion testimony of a non-expert witness based on familiarity acquired in order to authenticate the signature. Opinion testimony is generally inadmissible. Lay opinion testimony is only admissible if rationally based on the witness's perceptions, will be helpful to the trier of fact, and is not based on scientific or other specialized knowledge. Handwriting identification can be entered into evidence as a lay opinion if foundation is established showing a witness's familiarity with the handwriting at issue. A non-expert's opinion on handwriting, however, cannot be based on familiarity acquired in order to authenticate for the purposes of litigation. Expert opinion testimony may be admissible if it is based on knowledge, experience, and training of the expert, be beyond the normal experience of an average lay juror, be helpful to the determination of the action based on proven and reliable data and methods, and be an application of such methods and data to the underlying facts of the case. In this case, Dix denies writing the letter to Parker. Parker may testify through personal knowledge that she is familiar with Dix's signature and recognizes it. A qualified handwriting expert may also testify as to the identification of the signature. However, a non-expert witness may not testify as to opinions outside of his or her own personal knowledge. Opinion testimony of a non-expert witness based upon familiarity acquired in order to authenticate the signature in this litigation is an attempt to give expert opinion testimony without being a qualified expert. As such, opinion testimony of a non-expert witness based upon familiarity acquired in order to authenticate the signature is not a sufficient basis for the letter being admitted into evidence. Question number 3. Dora, once again, who was 8 years old, went to the grocery store with her mother. Dora pushed the grocery cart while her mother put items into it. Dora's mother remained near Dora at all times. Peterson, another customer in the store, noticed Dora pushing the cart in a manner that caused Peterson no concern. A short time later, the cart Dora was pushing struck Peterson in the knee, inflicting serious injury. If Peterson brings an action based on negligence against Dora's mother, will Peterson prevail? A, yes, if Dora was in fact negligent. B, yes, because Dora's mother is responsible for any harm caused by Dora. C, yes, because Dora's mother assumed the risk of her child's actions. Or D, yes, if Dora's mother did not adequately supervise Dora's actions. Take 10 seconds and choose the best option now. If you chose option D, yes, if Dora's mother did not adequately supervise Dora's actions, you'd be right. To establish a prima facie case of negligence, the plaintiff must show a duty, a breach of that duty, causation, and damages. Under common law, parents are not vicariously liable for the torts of their children. However, it is important to make sure that parents were completely passive and not negligent in any way that contributed to the child's tortious conduct, because parents can still be held liable for their own negligence. Here, Dora's mother will be liable for her own negligence if she allowed her child to create an unreasonable risk of injury to Peterson by allowing Dora to push the cart. Thus, Peterson will prevail on a negligence action against Dora's mother if Dora's mother did not adequately supervise Dora's actions. Question number 4. In a prosecution of Dale for murdering Vera, Dale testified that the killing had occurred in self-defense when Vera tried to shoot him. In rebuttal, the prosecution seeks to call Walter, Vera's father, to testify that the day before the killing, Vera told Walter that she loved Dale so much she could never hurt him. Walter's testimony is A, admissible within the hearsay exception for statements of the defendant's then existing state of mind. B, admissible because Vera is unavailable as a witness. C, inadmissible as hearsay not within any exception. Or D, inadmissible because Vera's character is not an issue. Take 10 seconds. If you chose option A, admissible within the hearsay exception for statements of the declarant's then existing state of mind, you'd be correct. Hearsay is an out-of-court statement being offered to prove the truth of the matter asserted in that statement. Hearsay is generally inadmissible. One hearsay exception is the present state of mind exception. A hearsay statement of the declarant's then existing physical or mental condition or state of mind is going to be admissible to show that the condition or state of mind, it is a statement about internal reality, nothing more. In this case, Vera's statement to Walter showed her present state of mind. She loved Dale so much she could never hurt him. A present state of mind is admissible as a hearsay exception. Thus, Walter's testimony is admissible within the hearsay exception for statements of the declarant's then state of mind. Question number 5. Owens owned Whiteacre, a dwelling house situated on a 2-acre lot in an area zoned for single-family residential uses only. Although it was not discernible from the outside, Whiteacre had been converted by Owens from a single-family house to a structure that contained 3 separate apartments, in violation of the zoning ordinance. Further, the conversion was in violation of the building code. Owens and Peters entered into a valid written contract for the purchase and sale of Whiteacre. The contract provided that Owens was to convey to Peters a marketable title. The contract was silent as to zoning. Peters had fully inspected Whiteacre. Prior to closing, Peters learned that Whiteacre did not conform to the zoning ordinance and refused to close, although Owens was ready, willing, and able to perform his contract obligations. Owens brought an appropriate action for specific performance against Peters. In that action, Owens should A, win because Owens was able to convey a marketable title. B, win because Peters was charged with no knowledge of the zoning ordinance prior to entering the contract. C, lose because the illegal conversion of Whiteacre creates the risk of litigation. Or D, lose because the illegal conversion of Whiteacre was done by Owens rather than by a predecessor. Take 10 seconds. Choose your best answer. If you chose option C, lose because the illegal conversion of Whiteacre creates the risk of litigation, you'd be right. Even if the contract is silent as to the quality of title, there is an implied promise by the seller that at the closing the title is free from reasonable doubt, lawsuits, or threats of lawsuits. Title is unmarketable if any part of the land is subject to adverse possession, encumbrances, servitudes, mortgages, or there are zoning violations. In this case, Owen's conversion is in violation of the zoning ordinance and building code. These violations expose Whiteacre's owner to litigation. Peters does not have to follow through with Whiteacre's purchase due to its being unmarketable with regards to title. As such, in an action by Owens for specific performance against Peters, Owens should lose because the illegal conversion of Whiteacre creates the risk of litigation. Question number 6. Dora was an 8-year-old girl. She went to the grocery store with her mother. Dora pushed the grocery cart while her mother puts items into it. Dora's mother remained near Dora at all times. Peterson, another customer in the store, noticed Dora pushing the cart in a manner that caused Peterson no concern. A short time later, the cart Dora was pushing struck Peterson in the knee, inflicting serious injury. If Peterson brings an action based on negligence against Dora, Dora's best argument in defense would be A. Dora exercised care commensurate with her age, intelligence, and experience. B. Dora is not subject to tort liability. C. Dora was subject to parental supervision. Or D. Patterson assumed the risk that Dora might hit Peterson with the cart. Take 10 seconds. If you chose option A, you'd be correct. Dora exercised care commensurate with her age, intelligence, and experience. To establish a prima facie case of negligence, the plaintiff must show a duty, breach of that duty, causation, and damages. The reasonableness of a child's conduct between the ages of 4 and 18 will be measured under a subjective standard. Here, the reasonableness of Dora's actions will be measured against what an 8-year-old with the same experience and intelligence would do while pushing a shopping cart. Dora's mother remained near Dora at all times, and Peterson was not concerned with the way Dora was pushing the cart. Dora seems to have acted like a reasonable 8-year-old would under similar circumstances. Thus, Dora's best argument in defense of Peterson's negligence action would be that Dora exercised care commensurate with her age, intelligence, and experience. Question number 7. Davis decided to kill Adams. He set out for Adams' house. Before he got there, he saw Brooks, who resembled Adams. Thinking Brooks was Adams, Davis shot at Brooks. The shot missed Brooks, but wounded Case, who was some distance away. Davis had not seen Case. In a prosecution under a statute that prescribes attempt to commit murder, the district attorney should indicate that the intended victim was A. Adams only, B. Brooks only, C. Case only, or D. Adams and Brooks. Take 10 seconds. If you chose option B, Brooks only, you'd be right. Attempt requires that the defendant intend to commit the crime and that the defendant took a substantial step towards completing that crime. Regardless of the underlying crime, attempt is always a specific intent crime. Lastly, transferred intent does not apply to attempt. In this case, Davis decided to kill Adams and set out for Adams' house. On his way, he saw Brooks and mistakenly believed that Brooks was Adams. Davis shot at Brooks but missed and hit Case. As such, the intended victim for the attempted murder would be Brooks, since transferred intent does not apply to attempt. Davis cannot be charged with the attempted murder of Case. Davis, however, could be charged with assault and or battery on Case. Lastly, setting out for Adams' house without knowing more is not sufficient to satisfy the requirement of substantial step towards completion. Question number 8. Defendant is on trial for the crime of obstructing justice by concealing records subpoenaed May 1st in a government investigation. The government calls attorney to testify that on May 3rd, defendant asked him how to comply with the regulations regarding the transfer of records to a safe deposit box in Mexico. The testimony of attorney is A, privileged because it relates to conduct outside the jurisdiction of the United States. B, privileged because an attorney is required to keep the confidences of his clients. C, not privileged, provided the attorney knew of the concededly illegal purpose for which the advice was sought. Or D, not privileged, whether or not attorney knew of the concededly illegal purpose for which the advice was sought or not. Take 10 seconds. If you chose option D, not privileged, whether or not attorney knew of the concededly illegal purpose for which the advice was sought, you'd be correct. The rule is that any communication between attorney and client or their representatives intended by the client to be confidential and made in an effort to obtain professional legal services is privileged in all criminal and civil proceedings unless the privilege is waived or one of the other exceptions applies. If the attorney-client communication is made to further what the client knew or should have known to be a crime or fraud, the communication will not be privileged. In this case, the government has called attorney to testify that on May 3rd, defendant asked him to comply with the regulations regarding the transfer of records to a safe deposit box in Mexico. Defendant's inquiry was clearly in response to the government's subpoena dated May 1st. So this communication was made to further what defendant knew or should have known to be a crime. As such, this communication is in fact not privileged. Question number 9. Ozzie owned and occupied Blackacre, which is a tract of land improved with a one-family house. His friend Victor orally offered Ozzie $50,000 for Blackacre, the fair market value, and Ozzie accepted. Because they were friends, they saw no need for attorneys or written contracts and shook hands on the deal. Victor paid Ozzie $5,000 down in cash and agreed to pay the balance of $45,000 at an agreed closing time and place. Before the closing, Victor inherited another home and asked Ozzie to return his $5,000. Ozzie refused and at that time set for the closing. Ozzie tendered a good deed to Victor and declared his intention to vacate Blackacre the next day. Ozzie demanded that Victor complete the purchase. Victor refused. The fair market value of Blackacre has remained at $50,000. In an appropriate action brought by Ozzie against Victor for specific performance, if Ozzie loses, the most likely reason will be that A, the agreement was oral, B, keeping the $5,000 is Ozzie's exclusive remedy, C, Victor had a valid reason for not closing, or D, Ozzie remained in possession on the day set for the closing. Take 10 seconds and choose the best answer now. If you chose option A as your best answer, you'd be correct. The agreement was oral. A land contract falls within the statute of frauds and therefore must be in writing. Courts will recognize an oral contract for sale of land if there has been part performance by the buyer. Part performance requires two of the following three in order to be satisfied. A, buyer takes possession. B, buyer pays all or part of the purchase price. Or C, buyer makes substantial improvements to the land. Here, Ozzie and Victor's land sale agreement was oral. An oral agreement for the sale of land is in violation of the statute of frauds. The court in this case will not recognize their oral contract as an exception to the statute of frauds because Ozzie only meets one of the requirements, i.e., paying part of the purchase price. To recognize such a contract, therefore, if Ozzie loses, the most likely reason will be that the agreement was oral. Question number 10, the last question in this grouping. A state statute requires any person licensed to sell prescription drugs to file with the State Board of Health a report listing the types and amounts of such drugs sold if his sales of such drugs exceed $50,000 during a calendar year. The statute makes it a misdemeanor to knowingly fail to file such a report. Nelson, who was licensed to sell prescription drugs, sold $63,000 worth of prescription drugs during 1976, but did not file the report. charged with committing the misdemeanor, Nelson testified that he did a very poor job of keeping records and did not realize that his sales of prescription drugs had exceeded $50,000. If the jury believes Nelson, he should be found A, guilty because this is a public welfare offense, B, guilty because he cannot be excused on the basis of his own failure to keep proper records, C, not guilty because the statute punishes omissions and he was not given fair warning of his duty to act, or D, not guilty because he was not aware of the value of the drugs he sold. Take 10 seconds and choose what you think is the best answer. If you chose option D, not guilty because he was not aware of the value of the drugs he sold, you'd be right. The four elements of a crime consist of a guilty act, a guilty mind, concurrence, and causation. In this case, a state statute requires any person licensed to sell prescription drugs to file a report with the State Board of Health if his sales of such drugs exceed $50,000 during a calendar year, and makes it a misdemeanor to knowingly fail to file such a report. The guilty act would be the omission to file the report that is required by the statute. However, the mens rea required for the statute is knowingly. As such, to be found guilty of committing this misdemeanor, Nelson must have had knowledge that he was required to file such a report. Therefore, if the jury believes that Nelson did not realize that his sales of prescription drugs had exceeded $50,000, he should be found not guilty because he did not act with the requisite mental state. As always, thank you for joining us on Bar10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. Because of that, we upload materials every single day at 8 a.m. Eastern Standard Time. Don't forget to like, subscribe, and click the notification bell so that you can be notified every time we upload new content. Look forward to seeing you on our next class.